Welcome to today's training. We will be going over Section 50 of the CMS Centers for Medicare and Medicaid Services Manual, Level 1 Appeals for Medicare Part C. Here are our learning objectives. By the end of this presentation, you will know what an appeal is and how it can be filed, what the appeal deadlines are, when the timeframe can be extended for an appeal, when the appeal case can be withdrawn or dismissed, the types of appeals we handle, what CMS requires from the reviewers, what and when written notices must be sent, provider disputes, also known as claim appeals for non-contracting providers, independent review entities, and their expectations. So what is an appeal? An appeal is a formal petition or a request to review an adverse benefit determination, denial of services, for reconsideration. Simply put, is a request for a second review. So who can submit our appeal requests? Well, the member, the provider on behalf of member, also known as a POBM, contracting or non-contracting, and the legally authorized representative of the member with a valid AOR or appointment of representative form can file an appeal. It is important that this AOR form be in the case file so we can complete this appeal. How can an appeal be filed? Expedited appeals can be filed over the phone orally, in writing by fax or mail, and standard appeals can be filed in writing only by fax or mail. We are not required to take web-based appeals at this time, but the plan may choose to do so. Timely filing of an appeal. A valid or timely appeal is requested within 65 calendar days from the date on the original written notice of denial. That means that in order for us to consider a case timely, it cannot be on day 66. That would be considered an untimely appeal. There are exceptions to the filing limit that can be made, as I have listed here for us, only when good cause is found for that late finding. Some samples of good cause late findings are initial denial notice was received late, the member was seriously ill and unable to appeal, a serious family event occurred, such as a death or a serious illness, or the member lacking capacity to understand the timely filing limits or the timeframes for appeals. Example, a member is hospitalized for 6 months or 3 months and they could not get to their mail sooner. We may take that as a good cause finding and execute on that appeal. The plan can make an attempt to obtain an explanation as to why the request was not filed timely. This is only, of course, if the member initiated that request, but there was no explanation provided. It is not a required step for us to do outreach, but we can as a courtesy. Please note that the turnaround time for the appeal begins the date the information establishing good cause for late filing is received. Next, we're going to talk about turnaround times, or known as TAT. This is going to be very familiar and a very important term for us. Turnaround times are basically our due dates, and these are our due dates. Expedited appeals are due within 72 hours. When an expedited appeal is granted, there's a verbal notice that's due immediately upon acceptance of expedited processing to the requester, and then our written notice or final notice outcome needs to be delivered within 72 hours of the appeal receipt date and time. Standard appeals hold a 30 calendar day turnaround time or due date, and the written notice is due by day 30th. And here on the very right, we talk about extensions. One thing to note about extensions is the only time we can do an extension is when it is in the best interest of our member. Keeping our members in mind and in the center of this, we can at times do an extension for the following. If there is a need for additional information from a non-contracted provider, and we need to ask for 14 more days to be able to get that information, we may do an extension in the best interest of the member. That will grant us 14 more days. If there is an extension that is justified due to extraordinary or exigent reasons, we may also take those additional 14 days. Now, we do need clear policies and procedures that tell us or the clinicians when and what will be considered extraordinary or exigent in order to be able to do those 14-day extensions. Our last type of extension is because the member requests that we do an extension. Perhaps we haven't gotten records and the member can get them for us, or they're trying to get them for us. So one thing that's important about extensions is they have to be in the best interest of the member. Otherwise, we're held to the 72-hour or 30-day calendar turnaround time / due date. So you see my little man's racing against the clock to be compliant and meet our due dates. We're going to look at our general appeal workflow for expedited cases. When we get a member, provider on behalf of member, or AOR request appeal in writing, whether mail or fax, or verbally, we're going to first identify if there is a formal denial. If we do find one, then that's a true appeal. If there is no formal denial of services, meaning no denial letter issued, then that is considered a grievance. Next, if an expedited appeal timeframe is approved, the member must always be orally notified of the approval, followed by the documentation in the case file. And that case needs to be turned around or completed within 72 hours of the receipt. Now, if the appeal does not meet for expedited processing, we also need to attempt to notify the member of the change from expedited to standard time frame, and that must be done orally and followed by a written notice. The case will then be transferred to a standard 30 days and will be completed in that time frame. We're looking at a snapshot of our turnaround times. So for standard cases for Part C, we have 30 days to complete that case. If we're granted an extension, we have a total of 44 days. For expedited cases, those are due in 72 hours. But if we do get an extension approval, that gives us 14 more days, turning that into a total turnaround time of 17 days. And for our payment disputes or payment claims, then we have 60 calendar days and there is no extension. We've been talking a lot about turnaround times. I'm sure by now you guys have our turnaround times engraved in your brain. But why is it important? If we fail to meet turnaround times, you get a big red thumbs down. You do not get to pass go. You do not collect $200. We go, or you go, straight to IRE jail. For a failed time frame, that's considered an adverse benefit determination. Even if we have not reviewed the case, that must be sent straight to Maximus, which is our IRE or independent review entity, and they're going to do the review. We're not required to do a review. We're required to send everything to them. We get the big red thumbs down. We're not required to notify the member either that we've sent this case to Maximus, but a failure to meet a TAT is a straight to jail card. Withdrawing appeals. Yes, there may be a withdrawal of an appeal by the party that requested the appeal to begin with. If there is a request for an appeal withdrawal, the request must be submitted in writing or verbally by the party. The health plan must clearly document the file. What's needed in the file is the date of the request to withdraw and the reason why the party is choosing not to proceed with the appeal. In addition, the health plan must send a dismissal notice to all involved in the appeal, provider on behalf of member, AOR, etc. The letter or dismissal notice must include the reason for dismissal. We need to include their two rights, which are the right to request that the Medicare Advantage plan vacate the dismissal action and the right to request a review of the dismissal by IRE. And a little more in the next slides. Appeal dismissals are next. This piggybacks on our prior slide. Dismissal notices must be sent for each of our scenarios below. If we get an invalid requester on an appeal, for example, the person making the request is not the proper party, we get to dismiss that case. An example would be we never got an AOR form. A non-contracted provider fails to submit the waiver of liability form or WOL, we get to dismiss the case. A little more on the WOL in the next slides. If we get an invalid request, and this simply think about a late filing case, right? We get to dismiss the request if that case is outside of the 65 days. If we get a withdrawal request by the appealing party, as seen in the prior slide, we send a dismissal notice. And if our enrollee passes to better life, when there is no financial interest in the case or liability on the case, then we get to dismiss that case and that appeal. Vacating dismissals. Now, dismissals are considered binding unless one of the following scenarios comes into play. One is the health plan vacates its own dismissal within 6 months for good cause. One example of good cause is what we talked about earlier. We found good cause for late filing on a case. That case would be due within 72 hours for expedited or 30 calendar days for standard of vacating the dismissal. So the clock starts the day we find that good cause, as previously stated. Second reason would be the appeal requester went to IRE or asked us to send the request to IRE, our dismissal, and we forwarded that case to IRE within that 24 hours of their request. If IRE comes back to us and says, hey, your dismissal was incorrect, and asks us to approve it and work that appeal, or vacates our dismissal, then we are subject to the same time frame, 72 hours or 30 days, of that request to vacate. And finally, if the appeal requester asks us to vacate our dismissal, same thing, it has to be for a good cause. If we do find a good cause, again, 72 hours for expedited, 30 days for standard of vacating that dismissal is the time frame for due dates. However, for this one, if there is no good cause found, a letter is sent to the member provider, whoever's requesting, letting them know that we did not find a good cause to vacate the dismissal, and the dismissal will stand. What's important is that this is not a dismissal letter. This is another letter telling them that we cannot vacate their dismissal. Their dismissal will stand. So here are our appeal types. We have pre-service appeal. That pretty much means that the service will be rendered in the future. A post-service appeal is when a service was already rendered after the fact. A concurrent appeal is actively happening. That means that the service is actively being received, the member's impatient, for example. And provider claim appeals, they're post-service appeals only. These appeals are related to a claim or service that has already happened in the past, and these do not have anything to do with our members. Decision making. This pertains to our physician and nurse reviewers, and CMS requires that the physician and nurse reviewers cannot have been involved in the original decision making at the front end. Thus, if I was involved in the initial denial review, I cannot be involved in the appeal review. Must be licensed and board certified and also up to date. Licenses and certifications up to date. Must have the proper level of training, expertise to review the requested service for medical necessity. And this is why we are here having trainings. We must be able to apply proper criteria and guidelines using the CMS hierarchy. We must also pass a yearly inter-rater reliability assessment with a score of 90% to demonstrate our knowledge and capacity. We must also be residents of California, meaning actively living in the state. Hierarchy for reviews. In this inverted pyramid, we see our hierarchy for reviews beginning with the Medicare Benefits Manual. National Coverage Determinations Guideline is next, followed by Local Coverage Determinations Guidelines, followed by our New Century Health Plan Medical Pharmacy Coverage Policy Guidelines, and then Milliman, which is MCG, and at the base is literature. This is the hierarchy for which our clinicians must do reviews, and this is the order in which we will review. If there is no Medicare Benefits Manual policy, we will then go to NCD. If there is no NCD, we move down the pyramid as such. Written appeal notifications. Here we're going to find what we are required to include in our notices when we send our final decision letters to our members. So for our favorable and unfavorable written notices, the first two items are the same. We send the notice to the requester. We send the notice to the AOR in lieu of the authorized representative in lieu of the member. However, we may send it to both. Now, focusing on the favorable decisions, we also need to include a written notice explaining our approval reasons in an easy to understand language. Our written notice needs to have the duration of the approval, its limitations of approval, and it's important to note that we also need to notify our members orally of an approval within 24 hours, and we need to effectuate that approval within 72 hours of that approval. What that really means is we need to have the authorization on file within 72 hours of notifying them of the approval. Now, for the unfavorable written notices, the written notice explains the denial reason in an easy to understand language. Also, the written notice explains the criteria used to make the decision and appeal rights, it's important that our notices always tell the members what guidelines or criteria we use to make that decision and their rights to get a copy of their records and those guidelines as well. In addition to that, this case, remember, unfavorable written notices must be automatically sent to IRE within 24 hours of denial with a written explanation. And we're not required to notify the parties that we sent the case to IRE. That's an internal process. Unfavorable written notices are partial denials, partial denials or full denials. Now, just in case we don't remember our due dates, we've been not talking about our due dates recently. Notices are due in 72 hours for expedited cases and 30 calendar days for standard. Provider on behalf of member appeal notices must be sent to both the member and provider. Member appeal notices must be sent to the member, and it is considered a best practice to CC the provider. Next, provider claim appeals for non-contracting providers or NCPs. NCPs may also request an appeal for a denied claim when a waiver of liability form is attached to the appeal. Now, this WOL statement is important because it tells us that they are not going to go after our members to bill them for any balance billing, regardless of the appeal outcome. The WOL must be filed with the appeal. Supporting documentation, including records, notices, x-rays, etc., needs to be submitted. And now, if we get a WOL, we don't need an AOR because they're not representing the member since they're not going to be billing the member. Notices of appeal outcome are only sent to the provider for claim appeals. These are true provider appeals. These are not our member appeals. The NCP may appeal anything from payment denials or reversals, downcoding, bundling issues, level of care payments, and partial payments. Continuing on with our provider disputes, provider claim appeals, once we get a reconsideration request for a claim appeal, we, the health plan, must make reasonable efforts to obtain the WOL. We need to document the efforts. The clock begins when the WOL is received. So once we get that waiver of liability form, that's when the 60 days starts. And if we do not get that form, we can dismiss the case. We will not proceed with an appeal case when the WOL is not received. And to finalize today's presentation, we're going to touch on independent review entities, IREs. These are considered level 2 appeals. Now, if you recall from our earlier presentation, an adverse appeal determination in whole or in part, which means a full denial or partial denial of a service appeal request, must be auto-forwarded to Maximus for IRE review. This is considered their second level appeal. The member does not have to call and ask for this. This is an automatic step. You can think of this as a benefit to the member, right? Because they're basically getting a second look at our decision to ensure we did right by them. Now for number 3, failure to meet turnaround time, that is still a level 2 appeal, but this is one where if we fail to meet level 2, we get that big red thumbs down. We don't get to pass go. We don't get to collect $200. We go straight to IRE jail. Basically, we don't even get a chance to do a review because we missed that time frame, and that's our penalty. So level 2 appeals are the next step. It's an auto step for us here at Part C for Medicare, and the member does not have to request this to happen. Here is our IRE case file requirement form. This is straight from the Medicare manual, Part C. You also see Part D in comparison, and every single checked box mark is what we're required to send when we send our case file. In addition to sending a cover sheet, which is a case narrative, we have to send all the information of the appeal, of that initial determination for that appealed case, the initial denial reason, the initial denial letters. We need to send a copy of the notices. Also, everything that we used for the appeal are including our letter of determination or denial or partial denial letter needs to be submitted to the IRE for review. There are differences, and this is again taken directly from the manual for Part C, and all this information is required to build that package to send to Maximus. Finally, wrap up. We just learned what the Centers for Medicare and Medicaid, CMS, expect from us. From when we receive the appeal, how we handle an expedited case, a standard case, when we can validate a timely filing, when we can do a good cause, how to execute our letters, what they want on our letters, we can dismiss, when we can withdraw. We learned about our reviewers and what they expect from us. It is our responsibility to handle appeals properly and fairly in accordance with CMS regulations. So let's do our due diligence to ensure we are compliant with our CMS requirements and that we handle each case thoroughly within the required timeframes and applying the proper criteria and guidelines for each case in the best interest of our members. That concludes our teachings for today. Thank you so much for attending.
Good morning and welcome to Part C and D Enrollee Grievances, Organization Coverage Determinations, and Appeals Guidance, Section 70 through 110. In these sections of the training, you will learn important aspects of the Medicare Advantage Plan Part C and D, specifically focusing on enrollee grievances, organization coverage determinations, and appeals. We'll go through the process of how decisions are made, how they can be appealed, and what happens if a decision needs to be changed. Section 70, Administrative Law Judge, also known as the ALJ, Attorney Adjudicator, Counsel, and Judicial Review. What is an ALJ? ALJ, otherwise known as the Administrative Law Judge, is an independent federal judge who conducts hearings and makes decisions regarding member appeals. They essentially act as the court in this administrative proceedings, determining if someone is eligible for benefits like Medicare. Who can request a hearing? If you're unhappy with the decision made by your Medicare Advantage plan, you can request a hearing. This can be done by any party involved in the reconsideration except the Medicare Advantage plan itself. There are 3 different types of levels of review, including the ALJ, federal court, and 5th level counsel. Each level has specific rules about who can request the review and how it must be done. For ALJ, any party except the Medicare Advantage plan as stated earlier. Federal court, any party to the ALJ or attorney adjudicator's decision or dismissal, including the Medicare Advantage plan. And lastly, the 5th level counsel, any party, including the Medicare Advantage plan, can request a review. If it is a 5th level counsel review, you must notify all other parties. When it comes down to your prescribing physician, your doctor can request certain determinations on your behalf without being your official representative, but they cannot appeal beyond the initial levels without your permission. Filing requests for review. Deadlines. You must file your request within 65 days of receiving a decision or dismissal. This pertains to the 3rd, 4th, and 5th level of reviews. No matter which level of review it is, you do have 65 days after receiving a decision or dismissal. Extensions can also be accepted if you need more time. You can request an extension for a good reason, but it must be done in writing and explain why the request was late and why you need the extension. Decision-making timeframes. For Part C, it's pretty easy to remember because for Part C appeals, there are no specific timeframes for decision-making at the 3rd level of review and beyond for Part C appeals only. However, an enrollee or other party must submit all evidence with the hearing request by the date in the request or within 10 days of receiving the hearing notice. This rule does not apply to unprecedented enrollees. This just about wraps up section 70. However, we are going to have a quiz after each section, so this is the first quiz out of 4. Quiz number 1, section 70. Who has the right to request a hearing at the third level of review involving an ALJ, administrative law judge, or attorney adjudicator in Medicare Part C appeals? Is it going to be A, only the Medicare Advantage plan, B, any party to the reconsideration except the MA plan, only the enrollee, or is it going to be D, any party including the MA plan? I'll give you a couple seconds. All right. If you answered B, you are correct. If not, don't worry, you will get some more chances and you can review this training if needed after this presentation. Let's go ahead and move on to the next section. Section 80, reopening and revising determinations and decisions. Who can reopen a case? Certain people like plan administrators, independent review entities, ALJs, attorney adjudicators, or the council can decide to reopen a case to fix a mistake or change a decision. When reopening a case, all parties involved will be notified in writing. Requesting a reopening. Criteria. You can request a reopening if there's a specific reason, like new evidence or a clear mistake in that original decision. This must be done within the allowed timeframes. I have put a chart here that separates the reopenings and the appeals. Reopening a case means looking at it again to fix mistakes or change decisions. Appeals means asking for a higher decision if you do not agree with the first one. So reopening and appeals can differ from each other for certain reasons as listed here. Types of reopening. Cases can be reopened for clerical errors, good cause, or fraud. I've listed 3 different types here. The reopening based on clerical errors, for example, would be the wrong data entry, math mistakes, or duplicate claim denials. For a good cause, it would be a clear mistake in the original decision. And lastly, it would be not a good cause for changes in law or policy by CMS. Timeframes for initiating a reopening. For plans, it would be 1 year for any reason, or within 4 years for good cause, or lastly, any time if there is actual proof of fraud. For IRE, ALJ, attorney adjudicator, or counsel, within 180 days for good cause, or once again, any time if there is proof of fraud. This just about wraps up section 80. Hopefully we are ready for another quiz. Section 80 quiz. What must a reopening request include to be considered valid? A statement of dissatisfaction. B, the specific reason for requesting the reopening. C, the enrollee's Medicare number. Or D, the date on the initial determination. If you answered B, you are correct. Kudos to you. If not, don't worry, you have 2 more chances to answer, and you can always go back into this presentation after to review what you missed. Section 90, effectuation. Effectuation requirements. Plan's responsibilities. If a decision is changed by another appeal entity, the plan must quickly provide the service or benefits based on the enrollee's health needs. Depending on the urgency, effectuation process will vary depending on the date of the original request was submitted. For that information, you can see our standard expedited effectuation Excel chart with the detailed effectuation times and days that specifically pertain to what time and what day the case is due and needs to be effectuated. Monitoring compliance. The plan must comply with the new decision and report back to the independent review entity and CMS if they do not follow through. The plan must comply with all third-party entity decisions if applicable. I have attached a chart here explaining the monitoring of effectuation requirements, which includes 1 through 4. They are: IRE sends the decision, the plan must comply, a reminder notice must be sent out, and you must report to CMS. These are 4 basic monitoring effectuation requirements that are used when it comes down to effectuation. All right, Section 90, Quiz 3. What must a plan submit to the IRE to confirm compliance with an IRE's decision? A statement of intent to comply. B, a copy of the original plan determination. C, a statement attesting the plan has effectuated the decision. Or D, a request for an extension. If you answered C, you are correct. Okay, last section of the day, section 100. Provider notices in hospital, skilled nursing facilities, home health agencies, and comprehensive outpatient rehabilitation facilities. Part C only. Hospital settings. Important message from Medicare. If a hospital decides you don't need to stay anymore, they must give you a written notice explaining your rights and how to appeal that decision. You can ask for immediate review by the BFCCQIO if you think you still need to stay in the hospital. The BFCCQIO stands for Beneficiary and Family-Centered Care Quality Improvement Organization. To them, you can go ahead and submit an immediate review if you feel like you need to stay in the hospital. Skilled nursing facilities, home health agencies, and comprehensive outpatient rehabilitation facility settings. Notice of Medicare non-coverage, otherwise known as the NOMNOC, NOMNC. Before your services end, the facility must give you a notice explaining when your coverage will stop. If you request for an immediate review, you must ask for a review by noon the day after you receive that NOMNOC letter. Fortunately, if you miss the deadline, you can still ask for a fast track appeal. I provided an example here to explain a little bit better. Imagine you are getting care at a nursing home and they tell you your Medicare coverage will stop soon. They give you a notice, which is the NOMNOC letter, saying that it will end. If you think you still need care, you can call or write to the BFCCQIO by noon the next day to ask them to review the decision quickly. If you miss this deadline, you can still ask for a review, but you need to do as soon as possible, and there needs to be a good reason why. So for skilled nursing facilities, home health agencies, and for comprehensive outpatient rehabilitation facilities, you would go ahead and follow these 4 steps and 1 example as I listed below. All right, last quiz of the day. Section 100, Quiz 4. What is the time frame for an enrollee to request an immediate review by the BFCCQIO after receiving a Notice of Medicare Non-Coverage letter, the NOMNOC? Is it going to be A, by noon of the first day after the day of delivery of the NOMNOC letter? Is it going to be B, within 30 days of receiving the NOMNOC letter? C, by end of the month? or D, within 72 hours of receiving that knock-knock letter? If you answered A, you are correct. By noon of the first day after the day of delivery of that knock-knock letter. Made it to the end of section 70 through 110. To conclude today, a few reminders. This training helps you understand the processes involved in appealing decisions made by your Medicare Advantage plan, how to request reviews, and what happens if a decision needs to be changed. It's important to know your rights and the steps you can take to ensure you receive the care you need. Thank you for listening to this presentation of sections 70 through 110.